Question: have you ever wondered why some things, like a life insurance check, magically seem to go straight to your loved one after someone passes, while other things, like the family home, get stuck in this thing called probate? Why does a bank account get handed over without drama, but the deed to a house somehow needs its own little court adventure? It's a question that doesn't come up at family barbecues, but for families dealing with loss, well, it's one of the first things that hits you like a truck. And here's a twist: does having a will magically fix all of this? Or could there be other tricks or traps built into how your stuff is titled? Before we get into it, let me promise you this. By the end of this video, you'll understand the simple but powerful difference between probate assets and non-probate assets, why some things transfer easily after death and others don't, and the planning moves that could save your family months of time, tons of stress, and yes, a whole lot of lawyer bills. Okay, imagine probate like waiting in a DMV line, but slower. And the person handing out your loved one's things is named judge. Yeah, court involvement. That's probate. Then imagine non-probate assets as the Fastpass at an amusement park. Somebody already scanned your ticket ahead of time and said, yep, you're good, go right in. That's the beauty of non-probate. So what decides which line you're in? It comes down to how the asset is owned or titled. That's the whole game.
For a comprehensive list of everything you need to know about probate, click the link in the description.
First, what are probate assets? Probate assets are things that are only in the person's name at the time of death, with no co-owners, no automatic transfer instructions, and no named beneficiaries. Think a bank account just in grandma's name with no payable on death beneficiary, or a car titled just in grandpa's solo name. A house that isn't co-owned or set up with rights of survivorship. When those items don't have a built-in transfer plan, the court has to step in to legally approve where they go. That's probate. And in Florida, it can take months and cost high legal fees. Now, what are non-probate assets? These are the Fastpass items. They bypass probate because they already have a transfer instruction built into them. Here's what can skip the court: accounts with beneficiary designation like payable on death or transfer on death, life insurance policies with named beneficiaries, retirement accounts like IRAs and 401ks with beneficiaries on file, properties held as joint tenants with rights of survivorship, assets owned by a living trust with a successor trustee. The instant the owner passes, the title or money goes to the named person. No judge, no line, and no courtroom drama. One you probably didn't expect: real estate. Homes are the biggie. If your loved one owned the home only in their name, even with a will that says, give it to Matthew, that home still must go through probate first. That's because the will does not override how the title is legally held. But if the home was owned as joint tenants with rights of survivorship or in a trust, boom, automatic transfer. It's not magic, it's just the law. Wait, so are you saying a will avoids probate? Well, here's where a lot of people get it wrong. A will doesn't stop probate, it just tells the court who gets what once probate is underway. It's kind of like a roadmap, but you still have to go through the court poll booth. Meanwhile, non-probate tools literally put the property in someone else's hands immediately without the need for probate at all. Look, I know talking about this means you've lost someone, or you're thinking about something you never wanted to think about. That's real, and the process can be confusing and emotional. But when families understand the difference between these asset types, they're not left shocked or stuck mid-process. They feel prepared, respected, and empowered, and that's what good planning does. What to do next? Check how your accounts and properties are titled. It changes everything. Name beneficiaries on every account that allows it. It's like handing future you a gift, but cherished ones get it. Talk to an estate planning attorney or a professional, especially for real estate, because a tiny word in a deed can change whether probate is required. If you're dealing with this after a loss, pause and breathe. You're not alone. There are trusted pros who handle these details every day. So that's the real difference. Probate is the court path, non-probate is the automatic transfer path. Know which one your assets are on, and you can protect your family from extra stress when they're already hurting. If you want help understanding what you have and how it's titled, I'd love to walk you through it.